The webinar will start in 2 minutes.
Okay, we're going to go ahead and get started. First of all, I'd like to welcome everyone to this webinar. It's the second in our legal series of events on helping donors create thoughtful and effective philanthropy in honor of RPA's 20th anniversary. This session is going to cover advocacy and lobbying, and then we're going to have a lot of opportunity for questions on specific scenarios. So please be sure to take advantage of the Q&A buttons at the bottom of your screen. And we're also going to have a few hypotheticals for you to vote on and test your knowledge at the end of this presentation. Now, before we get started, I do want to say that even though we do have an attorney with us, this is not legal advice. For that, you'll need to go to your own attorney if you ever have any specific questions. And I want to just remind everyone, put in a plug right now for you to give us feedback at the end of the session by taking a survey that we'll send to you toward the end of this presentation or directly after the presentation. Now, I am thrilled to have with us today Nicole Campbell. She is the General Counsel of RPA, and Nick came to us with 15 years of experience in the philanthropic sector. She worked as Foundation Counsel for Dalio Philanthropies, and she was also Deputy General Counsel for Open Society Foundations. And in addition to working with RPA as our general counsel, she is the managing partner of the Campbell Law Firm, as well as president of Build Up, which is a nonprofit capacity builder for specifically people of color. So welcome, Nick. Now, before we get started, Nick, so many organizations on this call do advocacy as a huge part of their charitable work. Lobbying is just one component of this. Why is today's conversation important for nonprofits and private foundations?
Yes, thanks so much, Renee. So it's really important because we know that advocacy is a very critical tool used by charitable organizations around the globe. And as you mentioned, lobbying is just one part of advocacy. There's lots of different types of advocacy that we'll talk about. But if you don't know what the rules are around lobbying for charitable organizations, particularly within the United States, I think it then restricts how creative you can be within your advocacy and how effective you actually can be. So understanding what you can do, what you can't do, what you can do as a public charity, what you can do as a private foundation is really helpful as you make grants, as you fund activities, and you really try to use the advocacy tool effectively.
So what are the rules that set the framework for this? Like, why is it that you can do certain things or not do certain things? I think a lot of people on the call are probably familiar with this, but just so we set the groundwork and get everyone up to speed.
Mm-hmm. So when we talk about charitable organizations, we're really talking about 501c3, section 501c3 of the US tax code. So you hear 501c3 organizations, but we're talking about charitable organizations and all of the regulations that come from that section as well. And so there are different rules for different types of charitable organizations that we'll talk about. But this is really where charitable organizations can say, this is what I can do, and this is what I can't do. We also are going to be talking about private foundations, right? Another type of charitable organization, similar to the public charity in that way. When you look at, and this is dropping down to the third part here, section 4945 of the code, this really addresses the things that private foundations get taxed on, like what we consider to be taxable expenditures. And so lobbying is part of those taxable expenditures. And so all of the rules and regulations that come from that section also apply here. And then we're talking about 501c4, because as we'll discuss, charitable organizations like public charities have a limit as to how much lobbying they can actually engage in. At some point, if you want to do even more advocacy or additional lobbying, you might consider working with or partnering with a 501c4. And so the 501c4 has different rules around lobbying that we'll touch on as well. And so when we think about the framing of the conversation and the rules that apply, we're really talking about these.
So what is the biggest risk? So we talked a little bit about there's a taxing issue, right, that foundations might have to deal with. What are some other risks that happen if they go astray of these rules?
Mm-hmm. So, we definitely have the reputational issues that might come about, because now what you're signaling is that you are not compliant with the rules that are governing charitable organizations. But it's also fines that are at stake, penalties that are at stake. And so when a charity engages in a lobbying expenditure, it could be an excessive lobbying expenditure if we're talking about public charities, or it can just be the fact that you have now engaged in lobbying as a private foundation. You are subject to different penalties. And so those are financial penalties that can be aimed at the organization itself, but also on any manager, that's including officers, directors, folks who knowingly, willingly engage in those kinds of transactions as well. They also face penalties. And then the ultimate penalty, which is, loss of tax exempt status, if you're doing this repeatedly, and repeatedly is usually more than twice. And so if you're engaging in lobbying expenditures repeatedly, you could ultimately lose your tax exempt status, which means that you would not be around as an organization anymore. You wouldn't be able to fund organizations and individuals around the globe in terms of advocacy or affect change. And so no one wants that result. And so that's why we really want to make sure that we are not hit with penalties, we're not losing our tax exempt status, and we know how to engage within advocacy in terms of lobbying and what we can and cannot do.
Do you have a sense of where these risks come from? Like, is it typically whistleblowers? Is it an organization that might be on another side of a particular issue? Like, how do these tend to surface?
Yeah, I think it's all of the above. It's really based on the kind of work that you're doing. So if you are engaged in very high profile, very visible work, then you are making yourself very known, right? The work that you're doing. And then you obviously have supporters for that work, but you can also have folks that don't agree with what you're doing. And so they're looking for anything. They're looking for, the media announcements about your work and saying, wait a minute, I thought, again, maybe they don't know the rules, and they say, well, I thought that charities couldn't lobby. And so they raise their hands and they say, I'm going to go to the IRS. I'm going to ask them to audit this organization. And audits can really start from just a phone call, a letter. And so it can come from anywhere. And so you want to make sure that you are complying with the rules. And so when an audit comes up or an examination comes up from the IRS, you are prepared to say, I have followed, not only do I understand the rules, but I have followed them, I'm compliant, and what we're doing is within the different frameworks, the legal framework that we started this conversation with.
Now, do there tend to be cycles in enforcement? For example, where, for an election year, if it's a major election or a minor election, does the enforcement seem to ramp up at certain times?
I think that's right. It's definitely, election years, I think the antenna go up a lot more for the IRS. I also think that we think about it on the state level as well. And I think that depending on the state that you're in, you might have the Attorney General being very active, or the Charities Bureau within the state being very active and asking questions. And again, having someone just raise their hand and say, I think this charity is engaged in work that it shouldn't be, or I don't think that they're disclosing what what they should, those kinds of inquiries can really launch investigations and examinations pretty quickly. And I do think that they increase in election years.
Okay, great. So now let's get into the rules a little bit more specifically now. And if anyone has a question, feel free to put it in the Q&A and we'll make sure to monitor it and try to ask as many during the session as we can.
Yes. Okay. So we've started talking about charitable organizations. And the first bullet is really talking about the fact that no charitable organization can get that status if a substantial part of what they're doing is attempting to influence legislation or lobbying, right? And that's just the bottom line when we're talking about charitable organizations and how they're set up and their status. They cannot engage in a substantial amount of lobbying, right? Now that breaks down even further because we're talking about charitable organizations. There are two types, public charities and private foundations. And with public charities, they can engage in lobbying. Just it has to be an insubstantial amount of lobbying activities, right? So you might hear folks say charities can't lobby. They're not supposed to lobby. And that's actually not true. Public charities can lobby. It's just up to a certain amount of lobbying that they can do. And we'll talk about each of these different ways to measure how much lobbying you're doing as a public charity. The first is a default, the no substantial part test. Is back to that first point that if you want to be a charitable organization, you cannot engage in a substantial amount of lobbying. And so even if you do nothing else, that is the default quote test that you use to say, okay, you can be a charitable organization and this is the amount of lobbying you can do. For the next is the H election. And again, we'll talk about this in a little more detail. It does get very technical, but you can then say, I think that substantial part test is a little bit, it feels like I'm guessing. I don't have a lot of certainty around it. And so I want numbers. I want to know how much expenditures I could actually do when it comes to lobbying. And so I'm going to take what is called the H election. And so that's just giving you real clarity as to this is the amount of lobbying that you can do given the amount of expenditures that you make on an annual basis. And so that's for public charities. For private foundations, on the other hand, they are completely prohibited from engaging in or funding lobbying activities. And we'll talk about, well, then how do they make grants to public charities that might be lobbying or other organizations that lobby? What does that look like? But know that private foundations, as a default rule, general rule, they are absolutely prohibited from engaging in lobbying. That means there's no de minimis exception. So it's not as though you say, well, it's only $5, it's only $1. It doesn't matter. That rule is an absolute prohibition.
So just to clarify, the public charities you're talking about here are the 501c3 charities. What about, we mentioned 501c4 charities. How would you differentiate those?
So when we talk about nonprofits, 501c3 organizations are nonprofits, 501c4 organizations are also nonprofits, but that nonprofit umbrella term then breaks down into charitable organizations, and that's when we're talking about public charities and private foundations. And then we're also talking about social welfare organizations, which are 501c4 organizations. And so 501c4 organizations don't have these lobbying limitations. They can lobby to any extent that they would like. They don't have this substantial part, no substantial part limitation. They don't have to take an H election to get a certain number. They can use all of their funds if they would like in terms of lobbying. And so you'll see a lot of public charities or 501c3 organizations have affiliated C4 organizations when they realize we have a lot of tools in our advocacy toolkit, so to speak, and we want to do more on the lobbying side. That's when they step into this 501c4 vehicle, which has unlimited lobbying ability.
Great. And I know you have some information on the types of activities that are included.
Yes. So the point of this slide is really to say, it's not just about grants. So a lot of times we'll hear, well, it's not a grant, or we're really just focused on grant making and trying to understand how much of the grant itself is lobbying, but it's everything. It's all of the organization's activities that we're looking at. It's what your employees are doing. It's definitely what your grantees are engaged in, but it's your consultants as well, your vendors. And so whatever language you put into your grant agreement, if you're concerned about lobbying or you have sort of restrictions on lobbying, you want to make sure they're also showing up in your consulting agreements, particularly when you're making agreements with for-profit organizations, for example, or individuals who may not be familiar with these restrictions that apply to charitable organizations.
Great. So we have a lot of questions about the difference between advocacy and lobbying. So now that we've laid the groundwork, can you go a little bit more into the details around what lobbying is and how it's defined?
Yes. So we've talked a lot around, and we wanted to set this tone and the framing for it. But when we say lobbying, what do we mean? Lobbying is a word that's used, just generally to say, this person is lobbying on the Hill, if we're talking about the United States, for example. But when we are talking about lobbying, we're talking about a very specific definition that exists under the US tax code. And how that definition is used is that lobbying is seen as certain efforts to influence legislation. That's it. Right? Certain efforts to influence legislation. So your question or your thought should be, okay, well, if there is no legislation, then we don't have lobbying. And that's exactly right. The question that comes up though is, what is legislation? What does that mean for this tax code definition of lobbying? And so when we say legislation, we're talking about all of these bullets here, right? We're talking about statutes, and I'll pull out a couple because I think sometimes they get glossed over or forgotten about as legislation for these purposes. Legislative confirmations, they're seen as legislation for these purposes. So if you start to say, this is how the committee should vote, you're sharing information, you're reflecting a view, you're doing all those things, that is it may be seen as lobbying because you have legislation in play. Budget appropriations, you're talking about a legislative body taking on certain amounts of funding for spends or allocating funding for different budget line items. That's all part of lobbying because the budget appropriations would be seen as legislation. And then you have ballot initiatives and referenda that we'll talk about in just a second, but we also see those as legislation. Now, one thing that I want to pull out here is that it includes, and this is the beginning of that section, it includes federal, state, local, and non-US, which means it is everywhere in the world, and it is at every level of government. So it's not just the federal government within the United States, it is it also applies outside of the United States and in different levels of government. And we'll talk through which members of government we will be talking about, but know that it's just not restricted to the United States. And there's only two types, direct lobbying and grassroots lobbying, which we'll talk about.
So a question here is the question is, I'll quote it. Someone told me once that a nonprofit can do everything short of saying vote for X. Is that a good way to think about it? And I know what your answer is going to be, but I'd like to hear it.
So we'll talk this through. We'll talk this through because there are some exceptions where you'll see that doesn't always hold true. What we want to understand or think about when we're thinking about lobbying is just asking some really key questions. Do we have legislation in play, right? Who are we talking to? And depending on the audience, do you have, and we'll talk about this in grassroots lobbying, but do you have a call to action, right? So when you start to think about lobbying, is this lobbying, is it not? Think about those three things. Do we have legislation? Like, who are we talking to? And do we have an additional act to do if we're talking to the general public? And I think that framing will help, as opposed to we can basically come right up to that quote line of do everything except say vote for X, because I think that there's lots of things along the way that may constitute lobbying even before you get to vote for XYZ. And we'll talk about that too. So the first type that we wanted to focus on is direct lobbying. What is it? It is a communication with a legislator, a legislative staff member, or any government official that's, quote, participating in the legislative process. You have to be talking with someone who has some decision-making power in the legislative process, right? That's without that, you're not really engaged in direct lobbying. We'll talk about some exceptions that might come up, but really you are talking about someone who has a decision-making ability within that legislative process. The next thing you have to do is you refer to and you reflect a view on specific legislation or a specific legislative proposal. Now, when we get into that specific legislative proposal, it's like, well, what do we mean? What are we talking about? You have to provide sufficient information that allows your audience to identify a bill or some other proposal that's being made when you're talking with them, right? So it doesn't have to be an actual pending bill. It could be a proposal that's based on existing law, but it's so clear to the person that this legislative member that you're talking to, that it is clearly a proposal based on existing legislation that they can act on. And so that's when you have all of those elements, you are in direct lobbying. What I want to pull out is that direct lobbying is not all government officials. So what I hear a lot is, well, Nick, we'll be talking to members of the government. And we'll be talking about this particular legislation. So we're going to be engaged in direct lobbying. And that's not necessarily true. It depends on who you're talking to. So again, if you are talking to someone in the executive branch, where they're not a member of the legislative body, they are not involved in the legislative process, then you're not going to be seen as being engaged in direct lobbying, because you need to have that member of a legislative body in order to be seen as engaged in that kind of lobbying. The other piece is litigation, right? So litigation can be a form of advocacy where you're bringing suits for around different causes or around different laws, right? You could actually be saying this law should be repealed, whatever statement or position you're taking on it, whatever you do through litigation is not going to be seen as lobbying. And just because you're engaged with the judicial branch doesn't mean that you're engaged with indirect lobbying.
And in addition to direct lobbying, there's also lobbying with the public, correct?
Yes. And so that kind of lobbying is grassroots lobbying, right? And so just like direct lobbying, you have a member of communication with a member of the legislative body. Here you have communication with the general public. So everybody else who is not a member of that legislative body or participating in that legislative process. You have to do the same thing, refer to and reflect a view on legislation or a legislative proposal. And the difference between grassroots lobbying and direct lobbying, in addition to who you're talking to, because of who you're talking to, you have to include a call to action. And what is that? It's basically saying, I've told you about this legislation, I've reflected my view on it, and now I need you to go out and contact a member of your legislative body to tell them to vote yes or no, or to do a particular act, right, as part of that legislative process. So you need to call the general public to act in order to be engaged in grassroots lobbying generally. And so these are just some examples of what a call to action can look like. It's not always that explicit statement saying, now go out and contact your legislator to vote yes or no. The IRS, the Internal Revenue Service, says, look, we can actually infer that you were intending to make a call to action here, right? And that's what the other bullets imply. So don't think that just because you don't have that explicit statement that you may not be seen as, putting out a call to action.
Thanks, Nick. I have a question that goes back to the executive branch.
Mm-hmm.
So the example someone raised is whether appropriations include how a governor might allocate funds using executive authority versus a state legislature decision.
Now, I think it's a good question. I think some of these may require additional facts for us to get right into whether or not that specific case is lobbying or not. But I will say, if you are dealing with budget appropriations for a legislative body where they're making a decision as to how to allocate funds, that's going to be seen as direct lobbying. When you're dealing with the executive branch, it depends. If that executive branch is part of a legislative process. They're part of that budget appropriations process as just a normal course of business, then it may be seen that you are influencing a member who is part of that legislative process, right? That budget appropriations process. So we can't necessarily say no at all times, even if you're talking to an executive branch member, it will never be seen as direct lobbying, because we need to understand the role that they play within that overall budget appropriations process.
Okay. Now, you mentioned earlier that there are 3 elements: the legislation in play, who we're talking to, and a call to action. Are there any scenarios where a call to action is not required?
Yes. So remember we talked about ballot initiatives and referenda, that they would count as legislation. We're talking about, are we engaged in lobbying? There's special cases, because within a ballot initiative or a referendum, you have the general public that is actually acting, right? They're the ones that are making that decision. There is no legislative body outside of the general public. So in that case, you might say, well, I just heard that grassroots lobbying requires a CTA or a call to action. And I just need to reflect a view. I have specific legislation, but I'm not telling them to do anything. So I'm fine. Just because you're talking to the general public here, in the context of a ballot initiative or a referendum, it actually shifts into direct lobbying, because here the general public is standing in as that legislative body. So there's no call to action required, because they are the legislative body here, right? You're talking directly to them. And so when you refer to the legislation, reflect a view, then you're doing the same thing as being engaged in direct lobbying in that case. So we wanted to pull that out, because ballot initiatives and referenda come up a lot. And just know that just because you are engaging with the general public at that point doesn't mean that you need a call to action in that case. Another exception that I wanted to talk about is the paid mass media ad exception. So a lot of this used to come up in the 90s and maybe even the early 2000s around billboards in particular, but it's really, billboards, television ads, radio ads, magazine ads. And what happens is, if there's a highly publicized legislation that's pending before a legislative body, where highly publicized is pretty much the average person in the general public knows that the legislation is pending, and you have an ad that appears within 2 weeks of a legislative vote, and you either reflect a view and refer to the legislation, or you encourage the public to communicate with legislators just on the general subject of the legislation. You're not saying go out and explicitly call your senator and tell them to vote yes on this particular bill, for example. But if you just have those things, so there's no real call to action, you're going to be seen as being engaged in lobbying. Because again, the position is that it is just so obvious that what you're doing is telling them to do something. A call to action is not required in that instance either.
Okay. We have several questions on what can you do. So I think that's what you're going to move on to next, correct?
When you say what can you do in terms of like what?
Things that are not lobbying, that are not constitute, they do not constitute lobbying.
Right. So let's talk about the statutory exceptions that come up. And these are pulled out because these are exceptions that exist within the code. So these are exceptions that Congress has said, these are real exceptions to lobbying. And whenever you engage in these kinds of activities, you will not be seen as being engaged in these activities. I also want to point out that in addition to these statutory exceptions, and to respond to that question, Renee, about like, what can you do? There are a lot of things, a lot of activities that you can lead, manage, and do. What we want to make sure is that you know what lobbying entails, so that when you know, like, okay, this is what I can't do, or these are the parameters for lobbying, now you know that anything outside of those parameters is going to be fine in terms of the lobbying rules, right? So we need to understand what lobbying is to then get creative and say, okay, well, how do we still advocate and do this in a good way without, either having this count as lobbying or not wanting to engage in lobbying at all. So these exceptions, they're 5, and we'll talk about 4 in detail, the first 4. So that's nonpartisan analysis and research, technical assistance, discussions of broad social issues, self-defense, and jointly funded program. Now there's an asterisk there because this is something that is reserved for private foundations and government bodies. And so what essentially happens is you can come up with a new or existing program, you're asking for funding to be allocated to that program and used. A lot of negotiation that happens in this instance, right? So you're bringing in your lawyers most likely and negotiating for this program, what it looks like, what it's set up for, the funding, and all of those communications are completely fine, and they're pulled out of being seen as the private foundation engaged in lobbying. And so we can turn to nonpartisan analysis and research. And so this is one that comes up quite a bit. I think that what people refer to it as quite frequently is the white paper exception. And essentially what you have to do here to have it be not considered lobbying is that you present a, quote, sufficiently full and fair exposition of the facts to permit the public to form an independent opinion or a conclusion. So it is a very thorough research paper where you have really talked about, here are the facts that are at play, here are the considerations that we want you to know. You don't have to present both sides of the issue, right? But it does have to be a thorough, well-researched piece of work. And it needs to be fact-based and rational. What you can't do within that report or paper is include a direct call to action, like in closing, go out and, you should actually vote yes on this thing or vote no, right? You can't include that as part of it. You can't distribute it only to people who are interested in one side of the issue. So it has to be broad distribution, putting it up on your website, sending it out on your newsletter, that kind of thing. We get questions about, well, we know how many people come to our website. We have Google Analytics, for example, and we know that only 15 people visit our website. Is that broad enough? And it doesn't matter. It's that you are putting it in a media that has the potential of having a broad reach. And
so it's about making it available. It's about the availability. Right. It's not secret.
That's exactly right.
Yeah.
That's exactly right. And it doesn't matter how many people actually show up or how many subscribers you have on your newsletter. And then the last is that you can express a view on specific legislation, but just remember that you can't include that direct call to action, right? That explicit statement like, go out and do this. And once you have that, then you would fall into that exception. And one thing I'll say about the nonpartisan analysis and research exception is that pamphlets don't really get us there. And so we'll see that sometimes where, again, they're very thoughtful, well-written pamphlets, but they're just too short, too brief to really fall into that exception.
Great.
And then the next we wanted to hit on was technical assistance and then discussions of broad social issues. So with
I just want to stop 1 second. There's
yes.
A question about the prior category. What if the analysis includes recommendations for changes to legislation?
Yes. That is
it still falls within the exception.
Yes.
Okay, great. Thanks.
Yes. And with the technical assistance, this is a response to a written request that comes from a legislative committee or a subcommittee, or some other governmental body that's asking you to speak on pending legislation, to give your thoughts. And when you come in and have that conversation, you can provide analysis, you could provide recommendations, you can really talk about all of the things you would like to in regards to that specific legislation or specific legislative proposal. What we like to see is that this request come on letterhead, come from or be signed by the person who's really leading that committee or subcommittee or the body that's taking the vote, and that it's in writing. Right? Sometimes you'll get calls, for example, and that's not, even if they say the exact same thing over the phone, it's not going to count. You want to make sure that it is written.
Would it be appropriate or inappropriate to ask someone to ask you for that technical assistance?
So yes, that is a really good question. When someone calls you on the phone, which happens a lot, when depending on the kind of work you do, you may actually have members of committees or subcommittees or bodies that are taking legislative bodies that are taking votes saying, hey, I know that you're an expert in this area. You've done a lot of work in this area. We'd love to have you, share your thoughts on this particular bill, for example. Can you, get on a call next week with a group of us and have that conversation? And at that point, you would say, no, I'm not able to participate in that conversation. But if you would like me to come and speak with your group, then, we would love it to, be on written, be on letterhead, be in writing, and have allow me to say, whatever it is I'd like to say, recommendations, analysis, the thing that they're asking you for on the call. So it's very common that is that kind of conversation that happens. And so do not be afraid to request it. It's not illegal, or it's not anything that is unethical. And in fact, you should, because otherwise, if you say, sure, I'll have the call, that's when you actually get into lobbying.
Great.
The other is discussions of broad social issues. And so sometimes I always think like, well, why is this an exception? Because, we've said that if we're not talking about legislation, then, if we're not referring to reflecting a view on specific legislation, then we are not engaged with lobbying. But I think because there are so many issues that might be the subject of pending legislation, folks have questions. And just for clarity, it's in the code that you can talk about economic issues, problems that are coming up, anything that even relates to pending legislation, as long as you don't address the specific legislation, and that will be seen as an exception to lobbying.
And then the last one is self-defense, correct?
Yes, this is self-defense. It hasn't come up that frequently, but essentially, Congress gives charitable organizations the right to defend their existence, their powers and duties, or tax exempt status. So if a pending bill is coming up where a charity feels that its powers and duties will be impacted negatively or are limited some way, that you have the ability then to go to a member of a legislative body and say, we don't want this to be passed. We want it to be repealed. We want it to be changed, that kind of thing, without it having to be seen as lobbying. Importantly, it's non-transferable. So you can then, fund a grantee, for example, to go do this on your behalf. And it doesn't apply to grassroots lobbying. So you can't, again, go to the general public and say, look at this law, this is awful, write to your senator and say, no on this particular legislation. Okay, so we talked about the Section H election at the very beginning, and we just wanted to highlight it here, that if you want clarity, quote unquote, like in terms of numbers, this is how much I can actually spend on lobbying expenditures, and here's what's considered lobbying, here's what's not. And taking the Section H election is the way to do that. So you file a form with the IRS. It's pretty easy, and once you file it, you've taken the H election. If you decide later on that you don't want to take the H election, you can revoke it by filing that same form. There's limits on the total amount of expenditures that you can make, and depending on your budget, the largest amount that you can spend is $1 million, right? For the largest organization or the largest budget that they have out there. There's also an upper limit for grassroots lobbying. So reaching out to the general public and asking them to then contact members of the legislative body, 25%. But this is a way to get you to have real clarity and certainty on, this is the amount that I'm spending on lobbying, and I know that I'm within the limits of what I can and cannot do. The no substantial part test, as we mentioned, if you don't take the H election, you have to follow the no substantial part test. And this applies, again, to public charities. Private foundations do not have this option because private foundations can't lobby at all. And so larger public charities may choose the no substantial part test instead of the H election because they might think I get a larger amounts, right? More than $1 million, where I feel like I can safely lobby and it's still seen as an insubstantial part of our overall activities. It might be riskier to take that no substantial part test. So we want to point that out. Again, with the H election, you have a number. This is the amount that you can lobby. With the no substantial part test, you're sort of saying, okay, I'm doing a risk management analysis where I think that I should be seen as not engaging in a substantial amount of lobbying.
So Nick, with respect to what gets counted as a lobbying expense, it's not just the communication, right?
That's right. That's right. And so one of the things that comes up is like, well, what actually is lobbying? So I know what it is, I know what it isn't, but what's actually included? And it's more than just the act of the communication that results. It's all of the preparation that goes into it, the distribution, the different parts, the drafting, the reviewing. All of the things that made that communication possible should be seen as a lobbying expenditure. So it's not enough, for example, for a funder, a private foundation to look at a budget and say, you know, you're looking through the proposal, you're reading like, oh, wow, there's going to be some lobbying activities or there'll be work done. And you get to the budget and you see that the budget does not line up with the amount of lobbying that's been described in the proposal. And you see that it's really just focused on the end result. There's no staff time that's being allocated to it. There's no overhead that's being allocated to producing that communication. And you want to make sure that you're asking questions so that you're clear on what exactly are lobbying expenditures.
So thanks for that. I know that we have a lot of foundations, private foundations on the call today. So can you speak a little bit to what they can do and how they should be thinking about their grantees?
Yeah, so we're getting now into grant making. So we talk about what lobbying is, what it isn't, what are the exceptions, and you know that private foundations cannot engage in lobbying and public charities can. So with all of that framework, you should be saying, well, how can I make a general support grant to a public charity that I know for a fact lobbies? And you know, they lobby right up to the insubstantial part test line. How can I make that grant as a private foundation? There's a general safe harbor that the IRS has created for private foundations. And that safe harbor provides that the private foundation can make a grant to a public charity as long as you don't earmark your funds to support specific activities of the grantee, right? So the general support proposal should not be requesting funding for specific projects. The public charity can describe the different activities that you'll be engaged in. You can say, you know, we'll be doing this project that's lobbying, or we're hoping to make sure that this bill or is passed. You can still talk about the different lobbying activities you'll be engaged in, but you really can't have the funding be earmarked to it or really be highlighting it in such a way like, this is what we'll be doing with your funds, because now we're getting into earmarking. You also then, on the other side, you can't say, well, sure, listen, I've heard about this general support safe harbor. And so what we'll do is I'll make the general support grant to you. It's completely fine, but I need a report on that lobbying activity, because that's really why I'm funding you. And I really need to find out how it's going, and you're calling and checking in on that specific activity. It blows the general support safe harbor, and you want to make sure that you're not earmarking. And so this is the same thing for annual reports. Annual reports about all of the activities of the organization, including the lobbying activities, are what you want to see. And when you follow all of those rules, you will be able to provide a general support grant to public charities that engage in lobbying. With project support. Oh, go ahead, Renee.
So one question is about C3s and what they can do with respect to C4s, and I'm thinking about a C3 as a private foundation as well. The question is, can a C3 distribute a communication from a partnering C4 that includes a call to action, as long as the C3 passes it on as an update from a partner, but doesn't themselves make a specific call to action in the distribution?
Who are you passing? If you're passing, if you're
let's say it goes
C3,
out in the newsletter. Foundation has a
right?
newsletter, and they pass along a communication from someone, a C4 that they partner with.
Yes. Okay. So if you're a C3 private foundation, that is an absolute prohibition, because you're basically taking the C4's call to action. You're taking a lobbying activity and sending it out to your readers as a call to action. That's what's happening, right? Technically. And so as a private foundation, I would say absolutely not. As a public charity that might be doing it, you can engage in that activity because it's lobbying and you have the ability to engage in lobbying, but you want to make sure that you are tracking that expenditure. So it's not like, okay, well, I'm going to just include it. It's not really our call to action, so we're fine. They're going, the question is, what will the IRS do when they come in to examine your communications, your books, things like that? Will they see this as you furthering a lobbying act? And I would say yes, unless there's some other facts that we just don't know about. But as the facts is written, I would say that would be seen as lobbying.
Okay. Now, I just want to back up. There are a couple of questions that came in that I want to make sure get covered. Does an H election need to be filed annually?
No.
Okay.
File it one time.
And this one, I think you just went over, but I'm going to ask it just to be sure. Do foundations need to have the grantee that engages in lobbying as an organization submit a project budget with lobbying separated out?
Okay, so that's a really good segue actually into the project support conversation, which is, we talked about how to make a general support grant, and now we're going to talk about how to make that project support grant. Let's say you're making a grant to support a project that doesn't contain lobbying, right? And that's the first bullet. In that instance, we just want to make sure that the line items are charitable and we're supporting charitable activity, right? Because there's no lobbying included, even if the organization itself lobbies. When you are supporting, the private foundation, you're supporting a project that contains lobbying, right? Lobbying is in the budget. We ask for a bifurcated budget, right? And that bifurcated budget basically bifurcates the budget into two parts: lobbying and non-lobbying. And so when you have that bifurcated budget, and let's just use numbers, right? It's a $100 budget, $60 is in the non-lobbying category column, and then $40 is in the lobbying column. So there's $40 worth of lobbying expenditures that are there. The private foundation can provide a grant up to the non-lobbying portion of that bifurcated budget. So up to $60 in that example, right? Can't provide 61, but can provide up to $60 within that budget and not be seen as earmarking the grant for lobbying. Now, you might say, well, how is this helpful? Like, what does this do for the private foundation? One, it allows a private foundation to fund a project that contains lobbying. And two, it allows the public charity in that case when they do the reporting, they don't have to say, this is how we spent your foundation funds, we spent it on this, we spent it on that. It is now, you can just report back and say, here's how the project is going, because you are in that project support safe harbor. That many folks call it the project support rule, right? So you're in that safe harbor where you don't have to find out, well, actually, did you spend it on lobbying? Let me follow up on that, because you have spent up to the non-lobbying portion of the budget, okay? One thing we want to point out is you can't just rely on the grantee's description of an activity as not lobbying. If in the proposal, you're reading things that are making, you're saying, well, is that actually lobbying? I don't say, or if they're describing it as education, but you're like, wait, you're talking to a member of a legislative body, you're going to be talking about this specific legislation, you've reflected it, you're going to be saying, vote this way or that. How is that seen as education? You have the obligation to raise that with the grantee for clarification. So the back and forth that happens with grantees is very important because you want to make sure that all of the clarifications come back in and are saved within the grant record. It doesn't mean that you have to revise the proposal. You can do the back and forth via email, but you want to make sure that when you step into that project support rule, that you are stepping in saying, I believe I am clear on the activities that are lobbying, that are not lobbying, and this budget is now reflective of that non-lobbying and lobbying split.
There's a question around the definition of project support. For example, if we provide a grant that is designated for early childhood with no other restrictions or guidance, would that count as project support?
I mean, I think that if it might depend on the organization, right? If all you do is early childhood, for example, then maybe you can take it as general support. But I think in those instances, you want clarity, right? You don't assume. You want to make sure that you are very clearly stepping into these either the general support space or you're stepping into the project support space. And I know we have a lot of different names for grants, right? So it's capacity building, there is project support, there's program support, all these different names that we use. But in the IRS's eyes, in the Internal Revenue Service's eyes, there's only two types of grants. There is general support and there is project support. General support is unrestricted. So in that early childhood example, if you can use those funds for any purpose whatsoever, as long as it's charitable, that's general. If there is any restriction, it should be used for capacity building, it should be used for project or for this particular program or for leadership, for example, that is a project in the eyes of the Internal Revenue Service.
So here's a question that I think a lot of foundations may face. When it says that special reports on activities should not be requested, does that mean that if we have a 2-year Gen Op grant, we cannot request an interim report after 1 year to trigger the final payment?
No, you can, it's a good question. And you can request interim reports, but I think at some point, what I've seen, for example, is we're going to be requesting interim reports monthly, right? Or we're requesting interim reports and you're tracking funding or you're tracking a particular program. The questions that are coming up are about a particular program. All of those facts tend to show that this is not a general support grant. This is not a grant where the grantee could have used the funds any way it would have liked, even though you have a real interest in one of their programs, but there's no restriction as to how they might otherwise use it. When you're constantly checking in, I think one, it raises questions around we can get into best grant making practices. And I think that's a longer conversation. But then from the legal perspective, you start to think, is this actually a general support grant where the grantee could have used this grant in any way it would have liked? If so, then why are we checking in so frequently? But if you're asking for just an interim report on an annual basis, I think that is completely fine.
So I know you have some information you want to share on the Lobbying Disclosure Act, but I'd like to get us to some of the hypotheticals. Mm-hmm. So let's move on to those. And for those of you who inquired, we will be sending out the slide deck afterward. And you can always feel free to send us questions and areas you'd like us to follow up on through future communications.
Yes. So we have some hypos, and I believe a poll will also come up. But just to read this out loud for everyone out there, we have hypo. The first hypo is the Torture Victims Protection Act of 2022, which Charity A supports, is currently pending in Congress. Staff from the charity have set up a series of meetings for victims to meet with staff of the relevant committees within Congress. Victims are going to share their experiences. They will not discuss TVRPA 22. Do we have lobbying?
Okay, another 10 seconds. And how did the vote break down?
Okay, so we've got 78% of folks saying not lobbying and 22% saying lobbying. So I'd love to hear why the folks that think there is lobbying, just someone pop into the chat as to why we think there's lobbying.
And while we wait for that, maybe you could tell us what the right answer is.
So, you know, I think if it is as it's written, that victims are going to go in and share their experiences, they're not talking about TVRPA, right? We're not talking about legislation. And so I would say it's not lobbying. Now, with that in mind, though, and this is why I wanted to see if someone would type into the chat, this is usually what happens in theory, right? Theoretically, this is what you want to have happen. Practically, what happens or what could happen is if you're sitting with the folks who are the decision makers, right, and they're asking about your experience, at one point, what if someone says, well, you know, this act is pending. How do you think that we should vote on that? Like, what do you think we should do? Have you trained the group of stakeholders that you're working with to answer appropriately? To say, we really can't get into that, but if you'd like, you can send, you know, all of the things we've talked through to get us into the exceptions to lobbying, if it does veer into that, is a question. But as it stands and as written, I would say it's not lobbying.
So I think we have time for one more hypothetical. Let's go to hypo 3.
Okay. So
and you can go ahead and put up the poll now while we look at the question as well.
Okay.
I'm going to read it.
A nonprofit employee makes the following statement. The Juvenile Justice and Delinquency Prevention Act regulates the incarceration practices among juveniles, including deinstitutionalizing status offenders. Research shows that incarcerating low-risk offenders is related to higher recidivism rates. What is your view on this issue? Lobbying?
And if you think it depends on some considerations, go ahead and put what you think those considerations are in the chat.
Okay, so we have about 90% of folks saying that it's not lobbying, and the remaining saying lobbying. And so we also have a couple of questions that are popping up in the chat, a few questions like, who are they talking to, right? Who are they talking to? And was there any additional language invoking a specific leaning on the issue? So do they just say this? Was there additional language before? What's the follow-up? And so, you know, I think those are all good questions, right? So if you're talking to a member of the general public, right? Like, where's the call to action, right? So I would say in that instance, it's not lobbying. If you're talking to a member of a legislative body, I think this is where you start to get into lots of questions around, okay, is it actually lobbying? And those questions that have been raised in the chat, like what was said before, was said after, would come into play. Because on the one hand, you could say, I'm just making a statement and I'm actually trying to figure out your view. But if you see, the first sentence is saying, this is what the act does. And the second says, research shows that incarcerating low-risk offenders is related to higher recidivism rates, right? So have you now referred to, reflected a view? Those are the questions. And so I think like you have to do that analysis if you're talking to a member of a legislative body.
Well, we have 1 minute left, so I apologize to those who we could not get to the questions. We also have a handy cheat sheet on an advocacy versus lobbying summary. So we will send that out, as well as short answers to the hypos when we send out the written materials following this webinar. So I'd like to thank you, Nick, for attending. Thank everyone for the great questions and the interaction and engagement. And we'd also like to encourage you to go ahead and take the survey about this webinar that's going to come out as soon as we close out the webinar. So thank you, everyone. Once again, I hope you enjoyed it.